Georgiou Law PLLC podcast. Clear your debt, claim your future. The show where we break down the laws that affect your financial life and help you understand your rights in the face of credit card lawsuits. I'm your host, Efstathios Georgiou, the managing attorney and founder of Georgiou Law PLLC here in New York City. Before we begin, remember that this podcast is for informational purposes only and does not constitute legal advice. Every situation is different, so for guidance on your specific case, please speak directly with an attorney. Today, we will be talking about a defense that many consumers do not even realize they have, and it can be one of the most powerful tools in fighting a credit card lawsuit: the statute of limitations. What is the statute of limitations? The statute of limitations is a legal deadline. It is the maximum amount of time that a creditor or debt buyer has to sue you after a debt has become delinquent. Once this period passes, the debt is considered time barred. The idea behind it is fairness. Over time, evidence gets lost, memories fade, and it becomes harder to have a fair trial. The law says that if a creditor waits too long to sue, they lose the right to take you to court. But, and this is critical, the statute of limitations does not erase the debt. It simply means the creditor or debt buyer cannot use the courts to enforce it. Well, we'll get into that later. They may still try to contact you by mail or phone, but if they sue after the deadline, you can raise the statute of limitations as an affirmative defense in your answer. The New York statute of limitations for credit card debt. Here's where things get specific to New York. For most credit card debt, the statute of limitation is 3 years from the date of your last payment or charge. This is due to a 2022 change in the law that shortened the period from 6 years to now 3 years. This is a complete game changer, folks, for consumers. Creditors used to have much longer time to file lawsuits, but now they must act quickly, and if they miss this window, the case can be dismissed if you raise the affirmative defense and you answer. So the key point: the clock starts to run from the date of your last activity on the account, usually a last payment. If you make even a small payment after that, it can revive or restart the clock. Well, how do creditors try to get around this? Creditors and even debt buyers, they know about the statute of limitations, but they try to work around it. 3 common tactics that they use. Number 1, reviving the debt. They will encourage consumers to make a token payment, and by doing so, the clock restarts or is revived. They will not disclose that the debt is time barred when they contact you by phone or by mail. And yes, folks, they will file lawsuits anyway, hoping that you do not know the law or you will fail to raise the defense in your answer. Remember, in New York, the court will not automatically dismiss a time-barred lawsuit. You have to assert it as an affirmative defense in writing and on time. Statute of limitations is an affirmative defense that is waived if it is not raised in your answer. Using the statute of limitations in court. When a lawsuit is filed, the statute of limitations has expired. Your attorney may do 3 things: raise the defense in your answer, explicitly state that the claim is time barred under New York law. Number 2, move to dismiss the case, filing a motion and showing the court the relevant dates and explaining why the claim is legally unenforceable. Or number 3, In some cases, pursue sanctions because suing on a time-barred debt may violate the Fair Debt Collection Practices Act or even New York's own consumer protection laws. There have been cases where the expired statute of limitations has led to immediate dismissal without drawn-out litigation and without trial. Protect yourself from restarting the clock. Please, folks. If you suspect a debt is time-barred, be aware of three things. Number one, do not make a payment until you've confirmed the statute of limitations status. Number two, be careful with written promises to pay. In some states, those can also restart the clock. Number three, keep your own records, such as statements, payment confirmations, correspondence. The best protection is to know your timeline and avoid giving the creditor an opportunity to revive the claim. So in closing, 3 takeaways. In New York State, most credit card debt lawsuits must be filed within 3 years of your last payment or charge. Number 2, the statute of limitations is an affirmative defense that you must actively raise in your answer. The court will never do it for you. And number 3, even one single payment can restart the clock, so act carefully. If you're facing a lawsuit and you think that the statute of limitations may apply, time is critical. Call me directly at 917-764-3072 for a free consultation. I will review your case, determine if your debt is time-barred, and fight to protect your rights. Until next time.